Thank you, Mr Deputy Speaker.
Thank you, member. And I call the member for Burdekin.
Thank you, Mr Deputy Speaker. Mr Deputy Speaker, I rise to speak to the Police Powers and Responsibilities and Other Legislation Amendment Bill 2018, a bill which will provide our hard-working police officers with the powers necessary to perform their job in a modern and certainly a fast-changing policing environment. In 2016-17, 8,292 people were reported missing to the Queensland Police. An astonishing number when you think of that number of people across Queensland who are going missing. Unfortunately, as we now know, 2 of these missing persons were later found to have been murdered and 31 were later found to have committed suicide. This bill will introduce a new concept to missing person investigations, namely searching places for high-risk missing persons. And a person is considered a high-risk missing person if they are under 13 years of age or there is a reasonable suspicion they may suffer serious harm if not found as quickly as possible. Mr Deputy Speaker, when a person goes missing, time is of the essence, particularly if that person is a young child. There are a number of cases around Queensland over many decades of people who have gone missing, and because a period of time has elapsed before resources were devoted to searching for those missing persons, they were never found. I know certainly in my patch of the Burdekin, the previous officer in charge of the Ayr Police Station, Senior Sergeant Mick Isles, has gone missing and never been found. Police officers need to be able to access a high-risk missing person's residence or a place of employment as soon as possible in order to carry out their investigations. Obviously, if foul play is involved, this consent may not always be forthcoming, hence the need to expand the powers of police officers to be able to enter premises in a timely manner, thus putting at risk valuable and potentially incriminating evidence or information. The bill will allow a police officer investigating the whereabouts of a high-risk missing person by allowing the police officer to establish a missing person scene at a place to search for the missing person or to search for information about the person's disappearance. And certainly with the advent of technology and in particular DNA evidence, that becomes absolutely crucial, that that crime scene or potential crime scene is preserved as soon as possible to allow our forensic officers and staff access so that they can conduct the necessary searches. Importantly, a police officer will be able to establish this scene under a missing person warrant issued by a Supreme Court judge or a magistrate. As a further safeguard before applying for the missing person warrant, the investigating police officer must obtain the authorisation of a commissioned police officer. Mr Deputy Speaker, other amendments in the bill address the complicated manner in which crime scenes are defined under the Police Powers and Responsibilities Act. And over a period of many years, those crime scenes have grown and certainly become more complicated to the extent where it is now very difficult and very time-consuming for police officers to establish those crime scenes. The dispensing of multiple definitions currently in use and the introduction of a new term of a crime scene threshold offence will simplify how crime scenes are established. The bill will define a crime scene threshold offence to mean an indictable offence which carries a maximum penalty of at least 4 years' imprisonment or an offence involving deprivation of liberty. Investigative impediments associated with accessing locked storage devices which have been lawfully seized under a crime scene warrant have also been addressed in the bill. And of course, I'm talking about devices such as mobile phones, computers, which have become an integral part of our lifestyle and in a lot of cases prove invaluable when investigating offences. The bill provides police with the opportunity to apply to a Supreme Court judge or a magistrate for an access approval order for a storage device that has been seized under a crime scene warrant. And Mr Deputy Speaker, it wasn't that long ago that mobile phones, I'll probably show my age here, but mobile phones, iPads, storage devices didn't exist. But we now live in that world where there's a rarity if you don't own one of those devices, and hence the need to update our PPRA provisions to reflect that most people these days have those devices, and of course when it comes to the commission of offences, they often prove invaluable. In line with changes in technology, it is important that our police officers are given the necessary tools and support by way of legislation to enable them to carry out their duties and, importantly, appropriately investigate the commission of offences. This includes providing police with the power to inspect electronic storage devices in the possession of a person who has been convicted of an offence of administering a child exploitation material website and or encouraging the use of a child exploitation material website. Mr Deputy Speaker, police currently have powers to take a person into custody for a reasonable period of time following a breach of the peace. However, police have no capacity to search a person who has been taken into custody to prevent a breach of the peace when they are required to be transported by police. Obviously, this poses a significant safety risk to both the person being transported and police officers involved in the incident. The search provision allows police to remove any items which could endanger the person or police prior to being transported. The increasing numbers of civilian watchhouse officers has meant that, unlike police officers, assaults against these staff members fall under the provision of the Criminal Code, which subsequently makes it very, very difficult to prosecute offenders under those provisions. The bill, I note, will introduce a new civil offence to appropriately deal with offenders who assault or obstruct a civilian watchhouse officer in circumstances that are not so serious as to warrant charges under the Criminal Code. Mr Deputy Speaker, the bill also extends the scope of Schedule 2 of the PPRA to include offences under Sections 221 and 223 of the Racing Integrity Act of 2016 relating to unlawful bookmaking and to opening, keeping, using or promoting an illegal betting place. And as you would appreciate, in order to investigate those types of offences, it is quite often necessary for a police officer to go undercover or to conduct covert operations in which to gather evidence. Additionally, the bill also extends the scope of Schedule 5 of the PPRA to include Section 225 of the Racing Integrity Act, which prohibits the use of a service or a facility an illegal betting place. This will allow authorised police to undertake controlled operations and controlled activities when investigating these offences. Mr Deputy Speaker, one of the more frustrating aspects of policing is dealing with offences where the driver of a motor vehicle fails to stop at the direction of a police officer. The percentage of unsolved evade police offences has increased from 46% to 63% for the period 2014 to 2017, and those figures confirm the extent of this problem. Of course, we all know the inherent dangers involved in police pursuits, and whilst I may not necessarily agree with the current Queensland police pursuit policy, I do see merit in the proposed amendments that provide for police to issue an evasion offence notice to the registered owner of the vehicle that requires the owner to provide certain information to investigating police regarding the identity of the driver. Of course, this doesn't help in the case of stolen vehicles, but will go some way towards identifying offending drivers. Mr Deputy Speaker, the transportation of an offender for the purposes of taking a photograph for a banning notice makes practical sense. Police need this power to enable offenders to be transported to a police station, a watchhouse or a police vehicle, as is necessary to ensure the continued effectiveness of police banning notices. And of course, they have come into their own in recent years with safe night precincts and ID scanners at nightclubs and those types of venues where intoxicated persons, for example, are banned from a precinct for a certain period of time. Mr Deputy Speaker, if I could move on to the amendments to be moved during consideration in detail by the Police Minister, can I say there is no more heinous crime than the commission of sexual offences against members of our community. And Queenslanders need to know that reportable offenders are being appropriately monitored and supervised upon their release from prison. Our most vulnerable deserve to be protected from these animals, and that's what they are. I'm calling it for what it is. I've had the misfortune, as I say, we'll call it, to come across some of these animals in my policing career, and they do need to be supervised and they do need to be monitored, because if we are to protect our citizens, and that includes women and children in our communities, then we need to make sure that we're keeping a very close eye on these offenders when they are released from custody. There's a fundamental difference here, Mr Deputy Speaker, between the position put forward by the government and that put forward by the LNP. Certainly there needs to be GPS tracking of repeat violent sex offenders until they die, the power to extend supervision orders, constant monitoring. They absolutely need to be in place to ensure that these people are being monitored at all times and the safety of our community comes first.
I thank the member and I